Welcome back to another episode of Work Comp Talk. It is a pleasure to be here once more. If you're new to our channel, make sure you hit that subscribe button on whatever app you listen to us on. Your favorite podcast platform is definitely a way for you to kind of keep in touch with us and check out all the new content that we're releasing weekly. We're very excited to jump on today's topic, but first, let me dive straight into our sponsors. Today's sponsors are Pacific Workers, the lawyers for injured workers. If you've been injured and you need a workers' compensation attorney, California has one of the best California workers' compensation attorneys in Northern California, and that's Pacific Workers, the lawyers for injured workers. You can reach them at 800-606-6999, or you can also check them out on social media everywhere. And of course, online at www.pacificworkers.com. Joining me from Pacific Workers is Bilal Kassem, president and co-founder of the company. And we're very excited to dive into today's topic, which is a topic that comes out a lot. It's funny, as we're writing blogs within the team and we're trying to understand, certain aspects of the system itself. There's one particular that I always kind of get hesitant to write about and stuck, because it can be a bit confusing. And unless you get it explained in a simple form, I can totally see an injured worker getting lost in this aspect as well. And that subject is pre-existing injuries. Within the California workers' compensation, there is such thing as you've been injured before and you got injured again. And how do you even deal with that? So Bilal, who best than you to dive into that subject with us today? Please elaborate. What happens when you're already injured and then you re-injure yourself?
So there are a couple of different ways to go about discussing this, right? Generally in workers' compensation, there's this topic or subject. It's called apportionment. Apportionment is just the technical term, meaning that when a physician is discussing apportionment of causation and apportionment of permanent disability, what they're referring to is the doctor attributing causation to sources other than the industrial injury itself, meaning that the doctor's evaluating whether or not, someone with a herniated disc had pre-existing conditions or pre-existing injuries, genetic conditions, whatever the case may be, that ultimately caused or contributed to their current condition. There's also the concept that the doctor also has to discuss to what extent someone has a permanent disability rating for an injury, what permanent disability is due to things that predated the injury or were around the same time of the injury but caused by something else other than the work injury itself. And so at a baseline, the doctor does have to address things outside of the work injury. The doctor, can't put blinders on and just focus on the injury. And usually the defense wants to point out these pre-existing injuries or disabilities or non-industrial sources to try and alleviate some of their liability.
So this is bad news for the injured worker, because essentially they could use your pre-existing injury or whatever, situation you had going on prior to your work injury to kind of blame everything on that and be like, hey, guess what? This has nothing to do with us.
Yeah, and you see that all the time in cases, someone may legitimately have pre-existing conditions. Someone may have had, I know, we were all kids once. I was adventurous. I flung myself off stairs on skateboards and, decided to climb trees, jump from roofs, like all the stupid stuff you do as a kid that, probably isn't good, but impacts you, or sports, hobbies, interests, whatever it is, ultimately throughout your life may affect you, and so a lot of people have called life experience that predates their injury, and that does affect them, right? And so maybe they had a work injury, and their work injury, caused them to have a need for surgery for their back, but maybe they already had a herniated disc that was there before, it just wasn't as bad, or maybe they have worn out cartilage in their knee, and now they've been a firefighter for 20 years or a construction worker for 20 years, and it's gotten worse, So the doctor does have a responsibility to address that, but the doctor also has to act within reasonable medical probability. So meaning the doctor can't just say, oh, well, you jumped off a roof as a kid, and so now the fact that you're blind in both eyes because of your work injury, I'm saying it's all due to that, right? It doesn't make any sense. So the doctor does have to take into account pre-existing conditions, but still has to associate the pre-existing conditions with the need for medical care. So you can't simply just kind of call one without the other, right? It has to make sense. So, ultimately the doctor still has to find that there's reasonable medical probability and a way to associate the two together without necessarily just pulling it out of thin air and making things up.
Right. And this is just me thinking outside the box. I just came up with a question, random ass question in my head, and I'm just going to throw it out there. What happens if, there was pre-existing conditions going on and that attributed to my new injuries or is part of, right? The doctor goes in and he's doing surgery. Has this ever happened, or have you ever heard maybe they see something else while they're in there and it's probably not 100% associated with that injury? Is a doctor able to go in and let me help this person out, fix this while I'm already here and open? Or do they ignore that? I had a couple of people ask that question. It's
a super important subject. And this is one that's we litigate this one a lot. And maybe not in a particular example. I'm trying to think of an example just based on a surgery scenario type thing that you gave. But to kind of touch on the subject matter, there's case law out there that actually requires that if there is a non-industrial condition that's present, and in order to treat the industrial condition, you have to treat the non-industrial condition too. The doctor or the insurance company is required to do that.
Wow.
So one of the things you see very commonly is diabetes, right? And people with uncontrolled diabetes can't go under general anesthesia and have surgery because there's a risk, bleeding and such, and problems that come up with that. And so ultimately you'll see a lot of surgeons say you have to get your diabetes under control first. And usually people with aggravated diabetes during a work comp injury, they're not eating right? They're not exercising. They don't have the means to purchase, their monitoring. They don't have the access to insulin and stuff. They don't have the tools they need to successfully control their diabetes. And so you'll see these cases where we force the insurance companies to pick up liability for treating the diabetes to get it under control so that they can have the surgery that they need that was caused by the work injury. And
That's interesting. I would have never imagined them actually wanting to take that responsibility.
They absolutely don't want to, but more often than not, they don't have a choice.
Right. I mean, I figured they'd probably say, well, you're screwed. You got diabetes, go figure that out. Then you come back to us. And even
they try to say that, or they try to, and, I can't think of any particular example, but just based on my knowledge of the law and cases that I've worked on, if someone had, maybe they had a pre-existing issue with their spine, but in conjunction, maybe there's a cyst there or something, and they also need a fusion, and you wouldn't be able to do a proper fusion without removing the cyst.
Right.
My understanding of the law and my experience tells me that we'd be able to force them to take care of all of it. And that would be picked up by the insurance company.
That would be a shame if they opened you up and they had to do something with your back, but then they saw a cyst and then eventually you have to get reopened just to get that cyst removed. That would suck. But I'm glad that they are kind of forced into, if it's in the way, you have to deal with it as well.
Again, though, it can't be it can't be elective, I think. You have to attach this medical necessity to it. So, for example, if I'm I got my tooth busted because of work injury, but, I never brushed my teeth. So, I'm like, hey, doctor, hook me up with some sweet veneers, to give me a beautiful smile, too, while you're in there. They're probably going to say no. The insurance company's obviously not going to see any need to make me have a beautiful smile beyond what was, caused by the work injury itself. But, if there's a medical need there, and we see that all the time. It absolutely happens. And similarly, it applies to death cases as well. A lot of people have pre-existing conditions which maybe could be terminal.
Right.
But if you have a work injury that accelerates or adds to their pre-existing condition, which would have been terminal in the first place, that can actually be a basis for death benefits to be awarded in California as well.
Interesting. And I know you've said this before, you've given numbers as to what type of percentage it has to be considered a work-related in order for it to be taken care of by workers' comp. Would you mind sharing that percentage?
Sure. It's 0.000001. It's seriously, if basically the law is such that if the work injury at all hastens death, and that's the technical term, hastens death, in any way, regardless of how small or how big, it becomes the insurance company's liability.
Interesting.
So
say someone has clogged arteries and they're working in construction, picking up heavy things constantly, getting out of breath and pushing their limits, I guess you can say. And then it just so happens that they flop and something happens at work and they unfortunately die. Just because they had clogged arteries and they had a history of that doesn't automatically assume that, this person died at the job site because they had clogged arteries. It could have been a matter of them picking up cement cases and like all this, heavy equipment, or even dealing with other type of machinery that could have caused, and it only needs to be 0.0000001%, right?
Sure. You bring up an interesting concept, though, and that's to the extent that the industrial exposure itself was the causative source. So, for example, in your example, they wouldn't have their industrial exposure wouldn't have caused their clogged arteries, right? So, in that example, I don't know that they would prevail. It would be a question of, there was some case law on this a long time ago, and it was basically that, just because something happens at work doesn't mean it's work related. There has to be an industrial connection that wouldn't have happened elsewhere. So it's like, for example, if I am walking down the hall at a building that I work at, and all of a sudden my knee just completely gives out, and as it turns out, I need a total knee replacement and I'm a mess, that might not actually be a workers' comp case, because that could have happened at the grocery store, that could have happened at home. It was just the right timing that I was at work when it occurred. So that wasn't necessarily caused by work.
Right.
But let's say, in your example, someone had some pre-existing cardiovascular disease, but they had orthopedic injury at work as a construction worker. They're prescribed medication. They had an adverse reaction to the medication, and due to the combination of the medication and their pre-existing cardiovascular disease, they, had a heart attack and died. That would absolutely be a workers' comp death case, 100%. And it didn't matter if the doctor said, look, the medication was only like 0.2% cause of this. This guy had severe cardiovascular disease in the first place. Again, that would still be enough for us to be able to get death benefits for any dependents that person had in California.
Right. 'Cause had they not gotten the prescribed medication the doctor gave or whatever it was that they were getting treated for, this person could have still been living for another 10 years.
Exactly. And so it didn't matter, in that case, if the person would have had a heart attack the next day anyways. It was the fact that the medication accelerated that.
How far do they go in and essentially dig in to see things that you probably would have had pre-existing? You mentioned being a kid, having accidents. How far can they go back? And how do they even get this information if you don't share it with them?
So normally when you report a work comp case, the insurance company will call you, just like car accidents. They want to gather information. They ask you how it happened, what doctors you went to and stuff. They may ask you to sign a HIPAA release for release of protected health information, to take a look at your medical history to see whether or not there's anything there that you had in your private medical records. If you're represented by an attorney, oftentimes what they'll do is they'll set your deposition. And for those that aren't aware, a deposition is a question and answer session, really, where they make you raise your hand, swear to tell the truth under penalty of perjury, so help you God, just as if you're testifying, before a judge or jury in court. And ultimately, it's that opportunity where they sit and they question you about your past medical history to determine whether or not you have pre-existing problems and pre-existing injuries, and ultimately whether you have anything there that they can latch onto to say that, hey, look, this person had an accident as a kid or a car accident last week, or whatever it is, to ultimately try to attribute causation to something else. And as far how back they go, as far as they can. They generally look for anything and everything they can to point the finger at. Whether or not there's medical records there, I don't know. It's it may be difficult to try and find records from 30, 40 years ago, which is something we see. We have a lot of clients who come through our office and they'll have their depositions taken and they'll testify, hey, I was in a car accident 25 years ago. I went to this doctor. As it turns out, the doctor is no longer even in practice. The records are nowhere to be found, whatever it is.
Happens all the time.
Yeah. And so, it's one of those things where the insurance companies would love to get anything and everything they can. But in practical terms, whether or not they do, it varies depending on the location, the doctor, how old it is and such. And sometimes they can't get the records. And then it's a question of, well, to what extent can pre-existing conditions be used if there's no medical records to address it?
What would you say is the percentage of cases that you see that, are tied into pre-existing injuries?
Oof, that's a tough one. I think it depends, quite frankly, what industry we're talking about and how old people are. I think a 50-year-old elementary school teacher is far, far less likely to have a lot of pre-existing injuries and conditions than, a 50-year-old day laborer or firefighter or,
You'll be surprised. Dealing with kids can be very dangerous.
If we're talking about emotional injuries, probably.
Have you not heard of all the shootings that have been happening? What if someone got shot at school by oh my God, I don't even want to think about it, but.
Yeah. And I was going to say, unfortunately, that's not that common, but apparently it is these days. So, that is a legitimate subject. I think, it's hard to say, but just the older we are, the more life experience we have. So the more likely it is we have pre-existing conditions. I think the biggest one you typically see is what doctors just referred to as collectively degenerative changes, meaning like just natural degeneration over the years, your cartilage and stuff wearing out, depending on how physical you are, that sort of stuff. Yeah.
Makes sense. So pre-existing injuries are significant within the workers' compensation system in general. There's a lot of things that, from what you're explaining, one needs to take into consideration. Mm-hmm. What if, for whatever reason, and I know you talked about depositions, and by the way, if you have not yet seen our video with depositions, you can find that video somewhere over there. And click on it and it'll explain everything that goes into a deposition, how to get prepared for it and what to expect. But what if you can't remember, or what if you accidentally forgot? Like, oh yeah, I forgot I fell off of a bike when I was 12 years old and I had a dislocated shoulder. What if?
So that happens a lot. And I always tell my clients this too, right? Like, I can't remember what I had 2 weeks ago today for breakfast, let alone stuff that happened to me like 25, 30 years ago. I don't know. And a lot of people forget those things, and that's okay. I think no one expects you to remember all of those things. And even when you're testifying under oath, like if you legitimately forgot about something minor, I don't think anyone really cares. Okay. I don't think it affects the case at all. I don't think it affects your credibility. I think the closer in proximity, time-wise it is to your injury and you forget, the more likely it is that it affects your credibility. Right. If they ask you under oath at a deposition whether or not you've been in a car accident and you were just in one 6 weeks before the work injury and you're like, no, I've never been in a car accident, right? You can't later be like, oops, I totally forgot about that.
Let me think about a scenario for that, because this is just me thinking as an average person. If I was involved in an accident 6 weeks ago, and then all of a sudden I'm in a deposition or I'm in a situation where I'm talking to attorneys and insurance companies about something that happened to me at work. However, that accident that I was involved with 6 weeks before, to me, was nothing. It was like, that was just, like a fender bender, or, someone accidentally swiped me or whatever. I wouldn't associate it. I would automatically be like, that has nothing to do with, I didn't get injured. However, I don't know. A lot of people, when you're in an accident, don't realize what happens to them till way later. Like, oh, this is a result of an accident that I was in, a month ago or 2 months ago. It happens. I see it all the time. So I don't blame someone for forgetting or not including that, because you don't necessarily think anything happened of it. And it's not until you're sitting in a situation where you're like, wait a minute, this is what's causing my headache. It's not because it's the sun and it's super bright, or I have, migraines. It's a result of the accident that I didn't even associate it. So it does happen. People can say and forget about that 6 weeks. I'm not trying to judge and I'm trying to find an excuse, but I can see this happening,
It does happen a lot. And people do take that stance. People are like, oh, I thought, you're asking me about car accidents. I thought you meant like at work or something like that. Or, one of the most common ones we see just in terms of that particular scenario is someone will say, no, the defense attorney may ask, have you ever been in a car accident? And the client will respond, no, I've never suffered injuries in a car accident. And what they did was they twisted the question in their head. And this is part of the important process of having an attorney and stuff when you're going through a comp case is when you're answering questions like this is we look at the entirety of your medical record and we spend a lot of time prepping with you as a client to make sure that one of the things we harp on the most is pay very, very, very much attention to the specific question and don't answer anything but the question. And so, if they ask you, for example, have you ever been injured in a car accident? You've never been injured, but you've been in 25 car accidents. Your answer should be no, not yes. And I've been in 25 car accidents, because that's not what the question asked. They asked about injuries in car accidents, not car accidents themselves.
Yeah.
And if you're really good about paying attention to the question itself, you can actually kind of like snake your way through a deposition to avoid damaging your case to the extent possible. And it's not that you're purposely hiding this stuff. You're just asked your specific questions and you're answering those specific questions. You're not hiding anything. You're paying attention to what's being discussed. And that's very important.
That's interesting that you mention it. And thank you for sharing that type of example, because I can see someone kind of listening to the question or taking the question a different way and answering more than they have to, which then essentially does come and benefit the insurance company, and it affects the injured worker. You might have not ever gotten injured in 25 accidents you've been involved in, but now that you've mentioned 25 accidents, guess what? As a defense attorney, I'm going to go look at your driving record and any history that I can find that associates the minimalist injury within one of those accidents that I can use against you to be like, guess what? You did have an injury.
Yep. And so to some extent, the doctors, let's say in that example, right, you had a pre-existing injury for a car accident. It was 20 years ago, but let's say there's no medical records.
Right.
But you've got a condition that could possibly be caused by both the work injury and the car accident, and the doctor has a hard time of determining to what extent there was a pre-existing condition there. Because maybe there's a documented claim for back injury associated with the car accident, but there was not much there.
Right.
The doctor may still say, hey, look, it's probable that this car accident, based on the mechanism of injury, then contributed to what you have now, even without medical reports.
Yikes. And I'm glad you dived into that, because I was going to ask something like that. What happens when doctors do see something, but there was nothing to back up that injury prior? I was going to go into what happens in that aspect, and you perfectly explained it. That can still come and bite you in the butt.
Yeah, and we fight that all the time, right? Because then we go into take the doctor's deposition. We ask them, as a medical professional and within your reasonable medical probability opinion, how is it that you determine that this at all contributed to what they have now in the absence of things like MRIs, X-rays, medical reports from even a chiropractor or, a doctor or orthopedic or otherwise, right? And we try to really chop down their opinion because apportionment itself is an affirmative defense, meaning it's the defendant's responsibility to prove apportionment to pre-existing conditions in the case. As an injured worker, your responsibility is to prove that you have an injury. Once that's done, anything the insurance company wants to do to knock it down becomes their responsibility. And so they have the burden of proof to make the doctor's opinion solid. It's not your job as an injured worker to do that, right? To rebut that. It's their burden. So if they don't prove up what they need to in the right way, it's their problem. And there is a case on this. It's a famous case called Escapado V Marshals, and stands for the proposition that when apportionment is considered, the doctor has to give the who, what, where, when, why. They can't just give a conclusory statement that said, oh, this person had a car accident, so 50% of their disability is pre-existing. They're not allowed to do that, like in any way, shape, or form. It has to be justified in a more meaningful way. So it's ultimately a little bit more complex, I think. But it's still something to be concerned about.
Interesting. Stop hurting your cat.
She jumps at me every text she can get. She wants to be on camera.
It's so cute. And now that you jumped into a little bit of what the doctor has to explain and the whole aspect of, I guess, getting to know what portion of it was due to a previous injury and what portion of it goes into the new injury or the new, I guess, symptoms the person has, how does that affect a rating or any type of settlement or monetary value to your injury?
So causation of injury and causation of permanent disability are two different things in some sense, but they kind of go together. You may not have one without the other in most cases. So for example, if you had a pre-existing degeneration of cartilage in your knee, and now you need a total knee replacement. And the doctor, may say, hey, you know what, because you had some pre-existing degeneration and instability in your knee, that's why you fell at work. So that's the apportionment of causation for the injury. But then also the doctor may say, well, it's also because you had pre-existing degeneration of cartilage in your knee and instability that also contributed to your total, your need for your total knee replacement, which then your total knee replacement leads to permanent disability. So in essence, it's contributing to both the pre-existing or the injury and then the permanent disability. And so what happens is the doctor assigns a percentage of the permanent disability that's due to pre-existing conditions. And in California, the percentage of permanent disability you have has a monetary value attached to it. So in essence, when you're reducing the percentage of permanent disability, you're reducing the monetary award that someone gets from a workers' comp settlement. And so we try to reduce causation apportionment for both permanent disability and injury as much as possible in cases.
Interesting. Good to know. So example, if you needed a total knee replacement, instead of you getting 100% for that disability, essentially now part of that percentage is going to be contributed to your previous injury, which from 100, you can possibly only get 20% now, which means less money for you.
Yeah. So, I've seen it where cases get knocked down tens of thousands of dollars, $100,000 plus. We fight over this stuff all the time. And on bigger cases, it's big money.
Interesting.
And it's very serious. And it's probably the most contested component of workers' comp cases because it really is, it can ruin a case. I've seen people who come to us where they went to a really bad QME or they had a bad treating physician and the doctor said that all of their symptoms, everything is due to pre-existing problems, and then after that, no, you see it all the time. You see someone who had, they're a construction worker for 20 years, they go to a doctor because their back's hurting and the doctor's like, no, you're just getting old. It has nothing to do with the fact that you're swinging a hammer and doing serious work for the past 20 years, or plumbers, electricians, with, you see this really a lot with shoulder injuries for those professions because they're working overhead a lot. And the doctor will say, no, your rotator cuff tear has nothing to do with the fact that you've done overhead work, 14 hours a day for the last 8 months straight. And you were supporting, a 150-pound pipe or, you tore something on a ladder falling or whatever. They were like, yeah, it's all pre-existing. It's from your youth league baseball 25 years ago.
Taking it back to your youth league baseball.
Yeah, we see stuff like that all the time, and I think that's the benefit of having lawyers to be able to fight on these things. But, even a lot of people come to us with these problems before they sign up as clients, and it's difficult for us to fight these things. We still fight it. That's what we're there for. But, it's easier for us to ensure that people are going with the right doctors from the beginning to avoid a lot of these problems.
Speaking about the right doctors, we also have another video that you guys can dive into. We're going to be linking that on the descriptions below. Or if you're watching this on YouTube, you can also click on the video here. But we do discuss about the advantages of getting to a lawyer that has essentially a list where they've already worked with tons of doctors in the past. And they know which ones are the good doctors and which ones are the doctors that are going to say 100% of your pre-existing injury is part of the reason why you're where you're at today. So that's a huge factor to consider as well. Knowing the doctors, the names of the doctors on those MPN lists is kind of also part of everything, again, in a workers' comp case.
Mm-hmm. Yeah.
I can't stress that enough. Well, we kind of dived into a little bit of everything that involves a pre-existing injury, but in a nutshell, pre-existing injuries happen all the time from what you're telling me. A lot of people have them. There are ways to deal with it within the California workers' comp system. If that is your case, if that's someone that's currently going through that, what would you recommend as an attorney?
I mean, definitely contact a lawyer, right? The apportionment issue is big. And most of the time, my understanding and, working on cases like this is there's room to fight. Certainly, if you do have pre-existing conditions, we can't hide that. And to the extent you do have pre-existing conditions that actually caused or are contributing to what you're going through now, it is what it is, but we can still make sure that it's appropriately addressed in a way that still maximizes the value of your case and reduces the impact on your ability to get benefits and get the medical care you need to address things. And to the extent you have non-industrial conditions that need treatment in order to treat your industrial injury and the insurance company's denying that, we know how to fight that too. So, I think most competent lawyers can, but I don't think you're not going to be able to do that on your own, certainly.
Good to know. Lawyer up then. All right. Well, thank you so much, Bilal, for diving into this conversation with us. If you are also listening to this on any of your pod platforms, make sure you hit that subscribe button so you can get notified every time we get a new episode up there. And if you're on YouTube, make sure you hit that subscribe button and the bell so you can also get the notifications when we dump some new content within our channel. Thank you for joining us once more, Bilal. We will catch you next week.
Thanks.